Hello, everyone. Welcome to our event today. Americans for Prosperity is honored to be joining all of you to launch the End Justice Fees Coalition. I know many of us have already worked together to advance solutions in this area in recent years, and I certainly look forward to working with you all even more, and especially on this important issue. Americans for Prosperity has joined this coalition because we believe that the fees imposed in the criminal justice system are just taxes by another name, and they ineffectively fund this important part of our government. I mean, you know this well. In too many places around the country, police and judges and prosecutors are being forced to become tax collectors just to fund their own budgets. Now, where does this lead? Well, for one, we know it has not improved public safety, but it's also led to unnecessary interactions between citizens and law enforcement, less time focused on solving and preventing crime, and an erosion of trust between the justice system and citizens in the community. So we're looking forward to discussing these issues more with all of you today. Thanks again for joining us to launch the End Justice Fees Coalition.
Good afternoon, and what a great welcome from our partners at Americans for Prosperity. And on behalf of the Fines and Fees Justice Center, I want to welcome everyone to the launch of the End Justice Fees campaign. My name is Priya Sarathy Jones, and I am the National Policy and Campaigns Director at FFJC. We are excited to have you all here with us today to learn more about how fees show up in our criminal justice system and what we can all be doing to end justice fees. Unlike fines that are intended to be punitive and in some cases an alternative to incarceration, fees are merely a form of regressive taxation. They prey on people who come into contact with the criminal justice system by charging them at every step of the criminal justice process. We have seen fees for booking and fingerprinting, fees for exercising your right to counsel and right to a jury, and even fees charged to a person for every day you are incarcerated, just to name a few. There are also many places that charge fees to fund operations and programs outside the criminal justice system, knowing it is easier to tack the cost of those government operations onto those who are most disenfranchised in our country, than equitably budget or use other budgeting policies to have their initiatives considered for funding. Governments do this because, one, it's easier than some of the other financial planning choices, but also because there is a belief that those people who come into contact with the criminal legal system don't matter, that they deserve it, that they don't have the power or voices that need to be heard. But this campaign and the efforts already underway across the country are here to show policymakers that these assumptions are wrong. Not only do impacted people matter, but there is also a great power with impacted people and communities. We know that there are ways to hold people accountable, and fees are not about accountability. And we know that everyone deserves a second chance. And a true second chance means that we are removing all the barriers to a person's pursuit of independence, security, and prosperity in America. Today, we will hear from partners, criminal justice stakeholders, and an impacted voice, and advocates working to end justice fees. We hope you will leave today's event more informed, more inspired, and motivated to do this work with more resources and partners in your efforts to end justice fees. And with that, I'd like to share with you a recent conversation I had with just a few criminal justice stakeholders. They really emphasized how fees show up in each one of their areas of work and impact their ability to advance and serve a fair and just system. I was honored to speak with Wendy Still, who has worked in the state government for 40 years and specialized for 29 of those years in adult and community corrections in the state of California. Prachi, an advocate and a defender, and a person who has a depth of experience working with those directly impacted by the fees imposed in the system of Washington State. And Curry Myers, a retired Kansas sheriff, a criminologist, professor, and an executive. All three of our panelists are here live in our chat today, so please feel free to ask them any questions and engage with them about their comments. Let's take a look.
Good afternoon, everyone. We are so excited today to have this really great, diverse panel of criminal justice stakeholders who are going to talk to us today about how fees impact their work, the work that they've done, how they cut against our public policy goals and our public safety goals, and what we need to do about them in our system. The criminal justice system is a large and complex system with a variety of stakeholders working across it. At nearly every touch point of the system, fees are charged. There are fees for public defenders, booking fees when you are arrested, prosecution fees, and programming and supervision fees when you are on parole or probation. And those are just to name a few. And while we couldn't have every stakeholder here today, each one of you represents a different but important part of the criminal justice system. So how would each of you say that the use of fees in the system impacts your work and cuts against the goals and missions of your roles? So I'd like to start this conversation today with Dr. Myers, who really represents the perspective of law enforcement as a former sheriff, and currently working in the field of how to deal with fees and fines and asset forfeiture. Dr. Myers.
It's a pleasure to be here. Thanks for having this event. I think a lot of people would be surprised, the general public especially would be surprised that a lot of police agencies and local governments actually rely significantly on fees from their citizens to fund budgets. Research shows anywhere from 10 to 50% is actually not generated through general funds. Police agencies, if we're going to have police agencies, they need to be totally funded through general funds in order to get away from this kind of policing for profit vision and option that doesn't bode well for the criminal justice system. Research also suggests that police departments who collect higher shares of their revenue from fees actually solve less crime because they're involved in chasing lower level offenders that apply to these fees, and we're not going after what we should focus on, which is violent offenders and recidivists. I conducted an in-depth research paper that discusses the impact of fees in policing. That can be viewed on my Substack site at drcurrymyers.substack.com, that found research that concluded that actually the cost of collecting this form of revenue consumes more than 100 times the resources than collecting the revenue through general funds. So there's no really return on investment for doing these fees. All it is a way for us to bypass core government services and not fund public safety through those core government services and do it fully.
Prachi, I'd like to kick it over to you as an individual who represents the defenders and this community who is oftentimes working directly with those who are impacted by these fees.
Thank you so much for having me, and thank you for the work that you're doing and that question. Absolutely, I think the greatest impact that I see on a daily basis is the impact on clients who do not have the resources to fund these ultimately, and certainly in the state of Washington, kind of locally based and sourced resources for courts and other kinds of judicial functions. Our clients on a daily basis bear the weight of these fees and fines, and they certainly are always in a position where they simply cannot pay them. What that means is that they bear the burden of these LFOs, legal financial obligations, as we call them in the state of Washington, and they bear them for a disproportionately long time. My clients of color, as we all know, are disproportionately impacted by the criminal legal system as well as the system of imposition of LFOs. And it does mean that their families, their communities carry these debt burdens for a much longer time. This means that this necessarily has not only an impact on them, but likely an intergenerational impact that changes the way in which they can access other resources. And when I say other resources, I do mean resources like employment and housing, because so many other kinds of relief, certainly here in the state of Washington with respect to criminal conviction history, is related to the ability to pay off your debt burden as it is related to the criminal legal system. So those are the ways in which I see these systems of funding our local court systems showing up on an individualized basis for my clients' lives.
Thank you, Prachi. And Wendy, from your perspective as someone who's worked in parole and probation supervision, how do these fees show up in your world and how do they impact your work?
In both Alameda and San Francisco County, where I was the chief, the fees basically have been used partially to fund supervision services, also public defender fees, and also alternative work programs, individuals being able to serve whatever their time is, not in jail, but in on an alternate work crew. And that's really important, because if an individual has employment and other things, positive things going on in their life, it works against that. But in terms of probation and parole, the biggest impact is it impacts their relationship, the client, with their supervising officer. It turns their officers into debt collectors. It also can contribute to absconding, because if they don't have the money, they don't want to go see their parole or probation officer for fear that they may be revoked. It contributes to recidivism. It crosses against public safety when you want to build the trust and legitimacy of the client with their officer. Also, it can impact families, the failure to pay child support, because an individual has to decide whether they're going to pay their fees or they're going to pay child support. It can impact their credit, housing, employment opportunities by the negative reporting. Some agencies charge for rehabilitative programming. We do not. It can impact their ability to access rehabilitative programs, and, such significant things as sex offenders, participating in mandatory treatment programs. It can cut across that if they don't have the money and you want them to participate in the programs. And those are just a few negative impacts. It also perpetuates the racial inequality of our justice system, because, as mentioned before, individuals of color basically disproportionately are involved in our justice system under supervision, and therefore impacted by these fees disparately.
That's great. And I know, Wendy, when you were working in Alameda County overseeing probation and prison post-release supervision cases, you really identified a lot of the things that you're talking about here today and how fees were harming the mission and goals of your institution. So what was your role in helping to eliminate those fees, and what did that work entail?
Well, it was an interesting process. The advocates opened the conversation up with me. And so I then prepared an in-depth analysis of the type of fees that were being collected within our jurisdiction, what the cost of collection was, the amount that was being collected, and the debt that was also owed by individuals that were no longer on supervision, and what the impact was to those individuals, some of which I mentioned, the impact to their credit, which could be a barrier to housing, employment, and so on. I met with the county partners to get consensus, to build consensus, which included the sheriff, the district attorney, the court, public defender, the auditor, and the county administrator. With advocates, and most importantly, with our clients who were impacted by the fees, so that I had a full picture of what was being collected, what the impact was, and then met with my individual board members or board of supervisors to discuss the issue and to basically present my views in terms of how it was harming the collection of these fees, was really harming and working against our goal, which was to basically have successful individuals within our community that had prior justice involvement. I presented this information then to the full board with a request basically to eliminate these fees. We, in our jurisdiction, eliminated both adult and juvenile fees. I prepared an alternative fiscal funding source. How would we basically close the gap, so to speak? And then I also partnered with a researcher so the research could be conducted on what the outcome was by doing this. We also forgave over $40 million in past fees, which basically were just serving as barriers for individuals to move on to their lives. They were never going to be able to pay these fees, but it was continuing to impact employment and so on. And as a result of all of this, our board approved the elimination of these fees. And then our legislature, the individual that chaired the Public Safety Committee was the senator from our district. And she subsequently moved forward with other legislature and eliminated the fees on a statewide basis for all of our 58 counties via a statute. So we were really pleased with the outcome.
That's Great. And I think you highlighted two really important points there. One, that local work can have such a meaningful impact on state work, right? You started out doing this work in Alameda County. You collected data, you worked with places, you monitored outcomes, and all of that really helped to shift the work in California and help propel that towards a statewide fee reform that's been taking place over the last few years. And also that you discharged the debt, right? That we didn't just make these policies forward thinking, but know that the harms have been there and they need to be relief for those harms as they've been occurring to date. And Prachi, you've done some work in Washington state as well on the issues of fees. Can you tell us more about what that work looked like in Washington and even where it's heading?
Absolutely. Thank you. We've been doing this work in Washington for a while now, several years, in fact, and there have been kind of generational movements towards ensuring that the debt burden from the criminal legal system is as low as possible for people in our communities. And so we certainly have made advancements when it comes to the consideration by courts as to people's poverty and expanding people's understanding of what that means. Poverty for people means many different things, but for a lot of people who are supporting their families and other members of their communities, I think we need to have a more expansive understanding of what it is that poverty is for people in those situations and what that translates to when it comes to the imposition of LFO debt for those individuals. And so we have been making strides towards that. So we have included in our statutes an expansive understanding of what it is that poverty means so that judges, when they are looking at kind of these debt burdens, look at the person in front of them and understand that person in their entirety and all of their current obligations that prevent them and preclude them, as we know, for the majority of people from being able to pay off this debt. And they certainly shouldn't be saddled with this debt that's come with a great deal of education across our systems for people who I think initially believed that people should and could pay these debts off. What we know is that people just cannot. And you cannot force money out of people who simply do not have it. And actually, in terms of public safety, it is better that they utilize any resources that they have in order to change their own lives, in order to create better lives for their families and their communities. And so we've done a great deal of education. Over this last legislative session, we made it so that certain kinds of debt can be waived entirely. In the state of Washington, for example, there are certain kinds of debt that carry a 12% interest rate, which is one of the highest interest rates in the country and is unheard of in many other situations. And so what we have done is started to make sure that those kinds of debt burdens are not carried. I think it's been mentioned before. I'll mention it again. People simply cannot pay it, and this is not a reasonable way to fund our current systems. The state of Washington, which isn't a unified court system, our systems are funded at the local levels, and it is done at a very, very low level with returns in terms of payments are like between 2 and 6% of the overall debt being paid back. In the future, what we are looking at is making sure that certain kinds of debt are not funded on the backs of individuals who are involved in the criminal legal system, and making sure that services are funded but not funded by them. So we have a couple of mandatory fees in Washington. One is the victim penalty assessment, one is the DNA fee. What we want to do is make sure that these services are funded, but they are funded adequately and they are funded in a way that is meaningful. And so what we're trying to do now moving into the future is to ensure that there is a crime victim and witness fund that is funded at the state level so that people do still get those resources that are very necessary for them to have, but they're not funded in the erratic way that we have done historically, and that has proven to be ineffective and frankly incredibly burdensome for people of color. Those are some of the things that we're doing moving forward, and understanding that, as Wendy mentioned, there's still incredibly important space to be held for retroactive relief moving forward.
Yeah, and Prachi, I think you've hit some really important points there, including that many of these services are essential to our functioning, to our government, and they do need to be funded, and they need to be funded from stable sources in the right way. And as many of our viewers already know, but it bears repeating, fees are distinctly different from fines and from restitution, right? Those two have different policy goals. The sole purpose of fees, as Dr. Myers touched on before, is to generate revenue in order to fund government operations, services, and our programs. And as I mentioned, unlike fines or restitutions that actually have different policy goals that underlie their imposition. So Dr. Myers, can you talk to us more about how relying on justice fees in our funding structure is not only harmful to our communities, but it's unreliable for our government?
Well, the cost of collections of these fees with those with outstanding unpaid fees often offset any monetary benefit whatsoever. There are some jurisdictions that are in excess of $1 million of fees that haven't been paid. So what occurs? Bench warrants end up being put out. There's special excise taxes almost that are put on people who haven't paid the fees. There's all kinds of things that could be done, maybe even garnishment of wages if they are working, which can be extremely dangerous. What police don't like to be is revenue collectors. We don't like the term. We don't like to be involved in that, but ultimately it forces a lot of law enforcement agencies to have to go out and try to find the absconders and make sure that they're paying their debts. We have to focus on reducing violent crime, focus on recidivism. In fact, more than 60% of violent offenders reoffend. And so if we spend more time focused on going out and investigating violent crime and going after offenders that reoffend, especially for violent offenders, and less time focused on these lower level cases, which a lot of these cases are when fines are established. Ultimately, it hurts the communities that are poor and disadvantaged as well. Many wealthier communities can have special court fees. For instance, Prachi talked about a DNA fee. Well, to have these kinds of forensic science fees makes it extremely difficult for us to solve cases in communities that may not have that wealth. Wealthier communities often will pay these fees with no problems. And so all of a sudden you may have a crime lab in a wealthier county that has an outstanding DNA program. It's well funded. They have an outstanding forensic science program, but you get into a poorer community and they don't have the money, that hasn't been dedicated, and the fees that are being assessed are not being paid by the people that are having it assessed to them. So these kinds of fees, especially on forensic science, really concerns me. That's the reason, modern forensics and modern evidence-based policing takes money. It's not easy to do, and that's why we need to fund these models through general fund capabilities as opposed to these special fees that go on.
Yeah, and Dr. Myers, you touched on this a bit. There is so much conversation going on right now about spikes in certain types of crimes and what is going on around the country. And it's definitely on everybody's mind. It's definitely in everybody's narratives. And the impacts that some of this has on various aspects of our criminal justice reform efforts that have really been taking place over the last couple of decades, and what this may mean for that, right? And there's also been a lot of defaulting back to tactics we know had not previously worked and have led to sort of long-term problems and implications that we're now trying to resolve and untangle. So, in real time, I really look at this work as prevention is better than cure. Anytime we can put policies on the front end that keep us from these long-term implications, we should. And so I'd really like you to speak to a little bit more about how does using a system like fees and the role that law enforcement ends up playing in assessing these fees, collecting these fees, as you said, often seen as the tax collector or the debt collector in communities. How does that actually cut against any other public safety efforts that we're trying to build, especially when it comes to community building and building relationships between law enforcement and the communities they serve, and how these two things collide when we're doing this work?
Well, it's one of those things that, and as we have economic troubles, local forms of government are going to rely even more on special fees to basically supplant the police budgets. We see that often in bad economic times. The real issue that we're seeing in a lot of these local areas, there's no oversight of the fee collection. There are some states that have mayor's courts that have little to no oversight whatsoever. So when you have mayor's courts where you can't put them in jail, but you can assess any kind of special fee that you wish, and that has come to be a specific problem in states in Ohio and states in Louisiana have had significant problems with abuses of mayor courts. I'd also like to remind that this isn't necessarily a law enforcement doing this function. Law enforcement doesn't build their own budgets. It's elected officials provide the budgets to law enforcement to go out and work. We have to have a re-education with the public and elected officials so they understand the warnings if they try to do these fundings through special funding mechanisms. They have a responsibility as the elected official oversight over those agencies to make sure that they're funding law enforcement appropriately and not doing it through this mechanism whatsoever. So this isn't a law enforcement black eye situation. A lot of times we're in a position where we have to carry out those things, but more often than not, these are things that elected officials decide to implement in their counties and cities, and sometimes states.
Yeah, that's a great point. Prachi, as a current practitioner, I'd really like you to speak to how you touched on this a little bit in the beginning with a few of your answers, but how do you see and understand the disparities of using fees in our criminal justice system, and who is it actually harming and how?
Absolutely, thank you. Yes, just to build on my previous answer, absolutely, when I see the ways in which fees play out and the imposition of them, and I see that here in the state of Washington, we see it across the country, is that it absolutely impacts our most marginalized neighbors and communities the most. My clients certainly fall within oftentimes those categories. And the difficulty, of course, as we know, is that they are the most likely to be enmeshed in the criminal legal system. And then from there are cumulative impacts, right? So they are more likely then to have higher degrees or higher amounts of fees imposed on them as part of their cases. And then because that cuts off oftentimes many opportunities, as Wendy talked about earlier as well, it means that they're likely to carry those debts for a longer amount of time. And so, like I said, these cumulative impacts really, really build up. And you see, 10 years from the point of imposition, 20 years from the point of imposition, one person's life who's in a marginalized position is drastically different from another person's life who had the ability to pay, for example, those fees off immediately. But that's not all, right? In the state of Washington, I think I mentioned this earlier, if you can't pay off your fees, if you can't pay off your criminal debt, you cannot vacate a criminal conviction. And here, if you vacate a criminal conviction, you can go out into the world and tell them that that conviction didn't exist, which is incredibly important in housing and employment spaces, which oftentimes do background checks. And that does mean that people will have fewer access to those resources and the stability that those resources offer. I think Dr. Myers mentioned this before, which are the kind of cumulative impacts of other kinds of collection attempts for clients. In the state of Washington, the utilization of third-party collectors, collection agencies, is a very widespread practice. And that does mean that once they get involved, oftentimes those debts are reported to credit reporting agencies. So things that we oftentimes take for granted, ways in which to increase our credit scores so that we can then get access to a certain degree of wealth or resources, are not things that our clients can. And so those are real life impacts for my clients in particular. I will mention another group of our clients who are disproportionately impacted by the system as it is right now, which are our clients with disabilities. Oftentimes our clients with disabilities are subsisting on a very, very low income. And in Washington, for example, where the courts have absolutely correctly held that those incomes cannot be extracted for the payment of criminal legal debt, it does mean that you are stuck in this liminal space where you cannot pay this debt off, you have such a limited income, Courts can't ask for that income for your debt. However, you have outstanding debt that simply cannot be waived. You are yet again stuck in this space where you cannot access other kinds of relief or cannot access other kinds of resources. So there are so many different kinds of impacts. And I think that oftentimes people think, well, it's just a monetary debt. It really isn't just that. It is a long-standing intergenerational debt and impact for our clients. And we see this on a daily basis. So I'm really grateful for you to open this conversation.
Yeah, you all have been so wonderful, I think, today in really making it clear how these fees are showing up in each one of your sort of lines of work or lines of touch with the criminal legal system, how they're harmful to our communities, to our governments, and really, to any pursuit of justice that the system is actually seeking to achieve, right? Our efforts to rehabilitate, to give second chances, to allow people to seek prosperity in this country. The way that we've been really setting this system up is for people to fail and to keep them trapped inside of this cycle of contact with the criminal legal system, all at the same time while not really achieving any real revenue goals. We're spending a lot of money trying to collect these fees. We're doing a lot of harm, and these many essential services just don't have a stable line of revenue, which, I think COVID in particular highlighted. When we don't have that, when things go awry, we're not able to provide essential services in the right way with the right public policy goals in mind. And it makes it even more important that we're actually thinking about these when we aren't in one of those circumstances, right? When we aren't in a recession or we aren't in dire constraints. So now that we have a better understanding, thanks to the three of y'all, what do you really think? Where do we go from here? What are the solutions in this space? And I want to start with Prachi and then Wendy, and then end with Dr. Myers.
Thank you for the question. So I think one of the solutions in this space, and I believe that the other panelists are going to be discussing this as well, is we need forward-looking relief for people, absolutely, and we need to make sure that these systems are not funded on kind of a user basis for the people who are involved in these systems, because of course that's remedying some of the harm for people who have experienced these systems. But I do think we also need a mechanism to look back. I think Wendy had mentioned the ways in which systems kind of are going back and looking at forgiving debt. How do we create systems within our current infrastructure to make sure that those kind of past debts are resolved, or people are relieved of those debts? Because as everyone has mentioned, people aren't going to be able to pay those debts, and hanging those around, having those hang around for people is really not a feasible way for court systems to function, but certainly for, a recognition for the impact on people's lives. So I really think developing those infrastructures is really important. We're seeing that here in the state of Washington, where last year the Supreme Court found that our drug possession statute was unconstitutional. And we are trying to understand how to forgive people of their debts and return their LFOs that had been paid back to them. And it's proving to be incredibly difficult to develop those infrastructures. I think it would be much better if they had existed in the first place for people to get that relief retroactively, as well as the work that you all are doing in terms of making sure that people have relief proactively and moving forward.
And Wendy, I'll kick it to you.
I think it's really important that we look at creating this as one important step towards transforming our justice practices as we reimagine justice in our country to be focused on success and accountability and move away from a failure-focused system. I think the transparency part of it is that we should be very willing to put dashboards out for our different law enforcement agencies on where we're at, not only with the measurement, collection of deaths, elimination of that, and looking backwards, eliminating that, but just in measuring our success overall, and also redefining what success looks like as part of all of the justice partners. But I think that the elimination of fees is a very important step in terms of moving forward, and also an important step to building trust and legitimacy in our justice practices.
Chief Myers.
Basically, stop supplanting police budgets through fees and fund them appropriately through general appropriations. And we as taxpayers need to be the ones that hold elected officials accountable for doing that again. That's the first step.
Yeah, I think this conversation was really great because it really highlighted, I think, the variety of things that go into fee elimination, right? And what it means to have fees in our system, that it's an unreliable source of government funding and stability for any services we're going to do. It's costly, both from executing it and the collections and resources, law enforcement time, court time, jail time, all of that. But also it's costly to our communities. What is the detriment and harm to people who are trying to make it day to day, and the impacts of being tied to this criminal justice system, and any little bit of funding that they may have go in their own pockets going back into a system just to keep them out of that system. And what does that do, as Prachi touched upon, to generations of families and communities that have been historically tied to these systems more than others. And I think, one of the most overlooked pieces is that it actually cuts against any of the goals and missions of all of the functions that are here today, but others that aren't represented. The ability for you to provide supervision services with the goal of success, the way that you do law enforcement with the goal of success and safe communities, the way that we provide public defenders and defender services with success and public policy orientation, victim services, and the list goes on and on, that those are all important things that have to be from stable, reliable sources of funding. And I think we can all work together in order to achieve these goals, which is another thing we really wanted to highlight today, is that these are different stakeholders, but they are partners. That's the word Wendy used. We're partners in doing this work and moving this issue forward. So once again, thank you all for being with us, talking about this and really uplifting how fees, which is an oftentimes overlooked part of this criminal legal system, shows up in your work and what we can all do about it to address it. So thank you so much.
What a great conversation. It really highlights how fees permeate our criminal justice system and how they do so in a way that cuts against public safety and efforts to help people reenter, all while disproportionately impacting our Black and Brown communities across the country. These fees turn our police and probation and supervision officers into debt collectors and hinder access to justice for those who are part of our system. And all of this impacts real people living day to day who are just trying to get by. People who are trying to hold on and get onto and get jobs, take care of their families, live in safe and stable homes, and be responsible citizens to their communities. Real people who may already have difficulties to overcome as they re-enter after a period of incarceration. 1 in 3 adults of working age in the United States have a criminal record. That probably means that at least 1 in 3 adults also have been assessed fees for their contact with the criminal justice system. And these fees accrue, and they carry severe consequences when they go unpaid. People lose their driver's licenses, they can't have their voting rights restored, they can't expunge their records, they can stay under indefinite supervision, and they can even be rearrested when they don't pay. And for all of our legislative advocacy and policy work, it is important to not only remember that we are talking about real people, but engage impacted individuals and communities in our work. As the saying goes, those closest to the problem are also closest to the solutions. Recently, I was fortunate enough to sit down and talk with a great human being named Zeke Gonzalez. Zeke has his own story about how criminal justice debt impacted his life, but also a story about how he learned from his choices and committed himself to being a wonderful and giving member of his community. Please listen to Zeke as he shares part of his story with us today.
Hi, my name is Zeke Gonzalez. I entered the justice system in 2010. I was convicted of a conspiracy charge. I fought the case to 2012, and I was convicted 2012. And in 2014, I received a life sentence for a conspiracy charge to distribute CDS weed. And I was lucky enough that before my incarceration. I was working at Tinker Air Force Base. I had just signed 6 more years with the Air Force Reserves, and I was attending SNU, Southern Nazarene University, receiving my bachelor's degree to become a supervisor there at Tinker Air Force Base. And then life happened. I was incarcerated. I received a life sentence. At that time, I didn't know what was going to happen with my life or anything like that. I didn't expect anything. I didn't expect to getting out anytime soon. The governor of Oklahoma, I received a commutation from the governor of Oklahoma, time served, and I was released from prison. My release from prison brought debt into my life. I had already started all over my life all over again out of negative, but then I was in debt also with that. So that was kind of a little difficult for me to start my life all over again. Especially with my qualifications and my background, I couldn't get a job in my field, which is aviation. So I had to settle for a job in delivery. I was delivering tortillas for about 6 months, making $300 a week. To me, that was promising for the point that I didn't want to go back to prison. And no matter what, I was not going to go back to prison. But I still felt this link to prison because when I was released, they gave me a $52,000 debt that I owed the state. With that being said, that lingering over my head and just having that link, I mean, it was more of a, not just only a debt, it was more a psychological aspect of it, where I had anxiety as far as if I missed a payment, I could go back to jail. If I did go back to jail, then I'd lose my job, I'd miss work and have to start all over again, and didn't know where to start all over again if that happened. I had an encounter in prison. I met a young kid, I'll say 26 years old, and we had a conversation, and he left me with something that stuck to me very closely. Again, at the time I had a life sentence. I had no plans of getting out, released. And my release, when I was released, I was like, there's something I can do for my community. There's something I can give back and help these kids or mentor them to stay away from the path that I went. So I opened up a nonprofit boxing center where kids come in, they train absolutely for free. We build up their confidence. They get a little bit of everything. My motto there is inner strength is key, which is that's something that can nobody take away from you, is inner strength, and mainly is knowledge. Nobody can take that away from them, and that's what I stress to them to get. The next thing is, from my encounter with the justice system, that the debt that I acquired from the justice system, that's why I'm here to, I like that you guys are a voice for these people that don't have a voice. Fortunately that I did have, someone, a support system, a network that did help me clear my debt. And there are those right now that are struggling with that debt and are going back to jail right now because of that debt. So I really want to appreciate you guys for doing what you're doing and helping others. And that's what I'm doing my part right now to help others also. Thank you.
Zeke has been on an amazing journey, and we are so grateful to him for not only sharing his experience with FFJC, but being willing and excited to share it with all of you as part of his dedication to helping improve the lives of others. Fees bind people to the criminal justice system. Even in circumstances where accountability has been addressed, the money individuals still owe to the governments can follow them for a lifetime. This drives many people further into debt, and it creates difficult decision points on a daily basis for people, oftentimes forcing many to choose between the needs of their families and making payments on their criminal justice debt. And that is why people are coming together to change things. Coalitions and partnerships are forming all around the country to address the issue of fees. And these relationships are not just progressives or conservatives. They cut across the entire political and ideological spectrum, bringing together community and faith-based organizations with national and state-led advocacy groups because they touch something at the core of all of our values: the pursuits of justice, fairness, opportunity, and freedom. A new poll conducted last month found that 62% of U.S. voters nationally across all demographics support ending fees in the criminal justice system. And 70% of US voters, including 76% of Republicans, believe that the justice system should be paid for by everyone. And because we know this advocacy works best in coalition and broad partnerships, today we want to share with you a recent conversation our partner, Jeremiah Mosteller at AFP, had with two advocates working in Oklahoma. He is joined by Damian Shade, the Executive Director of Oklahomans for Criminal Justice Reform, and Ryan Haynie, Criminal Justice Reform Fellow at the Oklahoma Council of Public Affairs. Two very different advocacy groups working together and alongside many others to advance this work in Oklahoma.
Thanks, Priya, and thanks to AFP's partners in this campaign, American Civil Liberties Union and the Fines and Fees Justice Center. I just want to echo what Emily Seidel said earlier. We are so excited at AFP to be a part of this coalition, and I'm particularly very excited about this panel today because I've actually been able to be on the ground some with the folks in Oklahoma and see the hard work that they're doing to advance their work in that state to reduce the impact of fees in Oklahoma. So I am honored to have Ryan and Damian here today for this conversation. And so I'm just going to jump right in though. Damian, I want to kind of kick it to you because we just heard from a panelist of national experts about what criminal justice fees look like naturally. So I'm wondering if you could tell us a little bit about what the status quo looks like in Oklahoma and how that may look different or similar to the national landscape.
Awesome. Thank you so much for that question and for having us here. As you said, my name's Damian Shade. I'm the executive director of an organization called Oklahomans for Criminal Justice Reform. Been doing this work for not quite a decade at this point in this state. In Oklahoma, our picture is fairly complex as it is in many states. Starting in the early 2000s, we see a pretty specific budget trend of taking revenue that went to district courts and to the administrative office of courts from taxes to pay for our court system, both the criminal, legal, and civil system, and that revenue beginning to decline as a share of the annual appropriation of what courts could do. The downstream effects of that are pretty profound and pernicious to the overall system. Since 2007, we've seen about a 30% increase in criminal court fines and fees. That is the fines, that is the criminal penalty to various infractions, and the fees, that's everything else. All of the other essentially revenue generating mechanisms, user fees, kind of like the way that we fund Netflix, right? That fee for service model. That's how the criminal legal system is largely funded in Oklahoma. In 2004, we saw that about 45% of the budget appropriations that went to district courts came from revenue or taxes. By the time we get to FY 2018, we see that about 94% at that year, a particularly high year, of revenue came from fines and fees. The bulk of those coming from the civil system, of course, but the criminal legal system still producing more than $30 to $40 million of fees alone, just from the executive agency fees. So on the downstream impacts, this has terrible impacts for state agencies that rely on these fees, terrible impacts for law enforcement that is forced to act as a collections agency for courts instead of responding to emergency calls or calls of serious crimes. We have law enforcement agents across the state that are enforcing failure to pay warrants as a huge piece of what they actually do. Those fees particularly really drive a huge amount of that because these agencies see, the Sheriff's Association sees a huge portion of its revenue annually wrapped up in those fees. You see that numerous state agencies, including prosecutors, though there's been some changes recently in the level of that, and law enforcement entities like OSBI and others reliant on those fees just to keep the lights on and to stay functioning. And the unfortunate fact is about 70% of those fees is assessed and never paid. Because it can't be paid. Our data analysis with the partnership with Open Justice Oklahoma and Oklahoma Policy Institute have shown that over the course of the last 2 decades, no matter how high we assess these fees, we believe that we've come to the theoretical limit of what can actually be paid, because the highest percentages of court debt in Oklahoma live in the zip codes with the highest poverty. That is, the highest poverty communities in rural Oklahoma. They're paying some of the highest per capita court debt in the state of Oklahoma, and we can drill into those numbers later. And then the highest poverty communities in high density communities of color, in the urban centers of Oklahoma. That's where all of the court debt lives. So the question that policymakers really have to address is funding courts, this important system of government that exists in Oklahoma on the backs of the poorest families in our state, is that smart, fiscally responsible policy? We have argued for quite some time that it doesn't make sense. It's not fair to courts, it's not fair to law enforcement, and it certainly isn't fair to communities in this state who essentially experience a multi-million-dollar regressive tax on their wealth that hits them each year.
Damian, that was actually a perfect setup for my next question that I want to pitch over to Ryan. Ryan, I know that OCPA does a lot of great work on tax and fiscal policy. So Damien kind of hinted at how the status quo might be problematic for agencies. But I was wondering if you could kind of fill in some of those gaps and tell us, have these fees actually been a reliable source of revenue for the state or state agencies? And how that might have changed given recent events like the McGirt Supreme Court decision?
Yeah, no, thanks for asking. So one of the things that we're always trying to look at is ways to find more stable revenue sources for the state of Oklahoma. And, you know, as Damien was talking about, fees are just not one of those stable sources. And the problem actually compounds, right? Because like other revenue streams, in good years, you know, when employment's high, and, you know, particularly in Oklahoma, when oil and gas is doing really well and there's a lot of revenue coming in from there, like, you know, everything's good, right? And then you have downtimes, right? Like any typical business cycle, and there are years where there's not as much. And so, you know, everybody feels that, right? And so the people who are already struggling to pay these fees, they're in the same position that everybody else is in, right? Where it's become really difficult to pay. And so, you know, that during a time where the state is already struggling to raise revenue, fees are also harder to collect during those times as well. And then you mentioned the McGirt decision. I don't know how familiar people are with that decision, but in 2020, the Supreme Court of the United States held that a large chunk of eastern Oklahoma is still an Indian reservation or part of Indian country. And what that has meant, and it really was for the purposes of the Major Crimes Act. And what that has resulted in is a number of criminal prosecutions that the state used to take care of, and on the back end assess fees to those to help pay and raise revenue for these agencies. A lot of those prosecutions are now either going to the federal government or to tribal courts, neither of which pay fees into the state and help fund courts and other agencies. Now, there are some interesting things going on between counties and tribal governments where there are some agreements that are being worked out. But at the end of the day, those are, you're basically getting a small portion back of what was already a very unstable revenue stream. And so we saw Senator Charles, I always want to say Charles Thompson's, Senator Thompson introduced a bill this past year to eliminate a good number, about $40 million worth of fees from criminal cases. And the reason, and he stated this on the Senate floor, the reason for that bill is because he's right in the middle of this McGirt zone in Indian country where these courts are being affected by that. And he saw firsthand that, these courts are just not assessing and collecting the fees that they used to get because of this McGirt decision. Now, that's a very a problem that is unique to Oklahoma. But I think it just goes to show that, and if it wasn't McGirt, it would be something else, right? Like, these issues are going on all over the country. But because this is an Oklahoma panel and we're talking about things that are sort of unique to Oklahoma, I thought that was worth bringing up.
Yeah, thanks, Ryan. I couldn't agree more. Damien, so you kind of hinted to some changes, particularly in how district attorneys have been funded. I was wondering if you could tell us a little bit about some of the reforms the legislature and Governor Stitt advanced related to district attorney funding and who supported those reforms.
Yeah, definitely. In 2019, there were some very significant reforms, which were the first steps, I think, in the process of really beginning to take the perverse incentive relationship that exists between officers of the court and the financial incentive that may run contrary to sort of the responsibility of justice. My district attorney, Steve Kunsweiler, actually was quoted in saying that he found it fundamentally immoral that there could even be the perception that prosecutors profit off of the cases that they prosecute. That perception has been something that I think, a long-term shared description amongst a number of DAs, law enforcement officials, and then, of course, folks in the business, faith, and reform community. Thinking about the idea that those individuals that we steward with the most awesome power that our society has, that is the power to deprive American citizens of life, liberty, and property, thinking that those individuals might also financially benefit from the use of that power is just fundamentally contrary, both to our values as a nation and our values as Oklahomans. So there were significant budget changes. Senate Bill 1068 took the funding that district attorneys were getting from their DA fees, essentially their DA supervision fees, and it took the funding and appropriated it over $20 million. So that funding now goes, those fees where they are collected now go into the general revenue fund instead of directly to district attorneys, and their offices have a $20 million increase in appropriation. This is a first step. We would like to see all of the executive agency fees and those sorts of things go that direction. So there is never the sense that a judge, that an officer of the court could be benefiting financially from decisions that are made in criminal legal verdicts. So it was a wide coalition of partners across the state that made that possible. And since then, there have been several other pieces that we may talk about in greater detail. Last year, one of the most significant of which was House Bill 3205, which essentially eliminated most of the juvenile fees that are written into statute at a reduction of cost of about $1 million a year for children in the criminal legal system. It's one of those terrible things that, obviously we won't talk about a lot, but these fees that are assessed to adults, many of them were before HB 3205 assessed to children who were interacting with the criminal legal system, including cases of child deprivation and cases that didn't involve criminal legal culpability, which is one of those pieces that is just particularly problematic, I think, and worrisome for the structure. Lastly, last year, we worked on House Bill 3925, which was a measure that essentially makes it significantly more difficult for folks to get failure to pay warrants for these fees when they're unable to pay them and unable to deal with them in the system. And that bill's going through an implementation process that will take about 1 year. But we see all of these as really profound positive signals that the legislature on a bipartisan basis is really interested in doing something with our governor to fix this problem long term.
Damien, that's great. And I was wondering if we could just kind of double click on something that you said earlier. And if you could tell us a little bit about what the experience is of folks in Oklahoma who are paying these fees, whether it be youth before these recent reforms or adults, and kind of what is the impact on them and their families very tangibly in Oklahoma? And how does that look different based on the community that those people live in potentially?
Absolutely. For children and families in Oklahoma, I cannot overstate the harm that these criminal court fines and fees have particularly done. Last year, one of our partners produced a report on youth justice and the juvenile justice system in Oklahoma going back a little over 2 decades, called the Better Tomorrows report, which we can share in the materials here. But in that report, they did qualitative data studies with more than 100 children across the state, and they found that significant numbers of them had resorted to crime to try and pay their fees to the criminal legal system. Significant numbers of them said they went back to selling drugs, that they went back to very antisocial behaviors, specifically because of the stress that paying even small fees meant for their family, right? Their brothers and sisters, who that extra 50 to $100 a month, that's food, right? That's food on the table. That's the ability to pay for medicine. That's the ability to pay for childcare. I grew up with a single mom in a pretty tough situation, and $50 to $100 could have meant the difference between us being homeless some months and us actually having a safe place to sleep at night. I think about the mom who got pretty low level drug offenses when she was 19 and 20, 2 decades ago. And for the last few decades of her life, she has said with her probation officer, she has the monthly conversation: which bills should I not pay so they don't take me back to jail? Should I not pay for my medicine? Should I not get as much food for my kids this month and just try and see what we can do? What do I need to do financially so I can not lose my children, not go back to jail, and not be afraid of the harms of failure to pay warrants and what they're going to do to my family? In rural and dense urban communities of color, this isn't a hypothetical. This is just a normal fact in the state of Oklahoma. And actually, the rural communities, some of the smallest rural counties in our state, are actually paying some of the highest per capita court debt in our state. In the smallest counties, the smallest 60 counties in Oklahoma are effectively subsidizing the criminal legal systems in Tulsa and Oklahoma County. So you have rural communities with some of the highest poverty rates, with some of the highest unemployment rates in our state, that are responsible for funding some of the most expensive courts in our state. It's not fair to those courts, the officers of those courts, the victim services that are downstream of those funding, and it certainly isn't fair to those communities to ask them, feed your children or pay to fund courts. It's not a standard that's fundamentally responsible, and it certainly doesn't support the belief that families and work should be incentivized.
Yeah, thanks, Damien. It's always important to look beyond the data to the individuals that are personally impacted by these policies. So appreciate you sharing some of those stories with folks today. I know that many people on this call have also seen those negative impacts firsthand. And so very excited that they're wanting to join this coalition. Ryan, I want to pivot to you because I know Damien and you have kind of mentioned a few of the different reforms that went on last year. And I believe, unless I'm wrong, there was 5 different bills essentially that were discussed in Oklahoma. Wonder if you can kind of tell us a little bit about, just very briefly, each of those, what succeeded, what didn't, and what were the barriers to some of those being successful in the legislature?
Sure. Well, Damon already talked about 2 of the 3 bills I was going to discuss, because those were the 3 that I sort of had some involvement in, being House Bill 3925, 3205, and but another one that I really want to talk about because it's sort of personal to me was Senate Bill 1532, which was a Senator Daniels and Representative Talley bill. And the reason I worked on that bill is because I got to know a guy that I go to church with who went to prison for trafficking in 2013. He's been out several years. And as I got to know him, I really wanted to try to help him in any way that I could. And so we went to lunch, and I was thinking along the lines of like, can we get some expungements or a pardon or something along those lines? But I was surprised that what he told me was the biggest issue I have is with my court debt. And so I pivoted and started thinking, okay, well, what can I do to help him with his court debt? And so what I found was that Oklahoma has a law already on the books that allows, if somebody has gone to prison, they get out and they are making installment payments on their court debt, then after a certain period of time, the judge has discretion to waive all of that. And I thought, well, that's a great statute. Like that works exactly for my friend here. And in addition to that, they also have to be following the rules of their probation or parole. And so I thought, well, that's really great, but this doesn't include people who did not go to prison, right? So it was limited in that sense. And so we got together with Senator Daniels, said, hey, what if we expanded this rule so that it not only gave the judge discretion to waive court debt in situations where the person went to prison, they've been out, they've been making installment payments, but what if we made it automatic? And what if we expanded it to people who did not go to prison, right? They received a suspended or a deferred judgment, and but they've still got court debt that they're paying on. And we maybe lengthen the time, same rules apply. And I thought that was a great bill. I was very excited about it. I will say that so that bill did not pass out of the House. It did get out of the Senate, I think, without a single no vote, if I recall. So it got out of committee and off the Senate floor without a single person voting no. And unfortunately, we just had some weird political issues going on in the Capitol this year, and there was a decision made on the House that they were just not going to move forward with that bill, and some of those things just come up, right? It's not about the policy. It's not that people think it's a bad idea. It's just politics, and I think that's unfortunately just a part of the game, right? That's a part of the process. It's an ugly part of the process because we're all here on sort of different sides of the political aisle because we want to see good policy. But unfortunately, sometimes politics just gets in the way of that.
Yeah. And Damien, I'd love to pivot to you for a second because Ryan talked about this debt forgiveness mechanism, which we see in a lot of states. Wondering if you can kind of drill down on how that's been playing out in practice a little bit beyond what he discussed, and maybe why our coalition, this coalition that's being launched today, has decided to actually go for elimination of fees rather than these other mechanisms. What do you think the difference is there, and how does that court process maybe not achieve the goals that we all want to see?
So the debt forgiveness piece is definitely an important mechanism. I still think there is value to it. We don't think enough, I think, as policy experts about the notion of incentives. And we know in research that positive incentives are 4 times statistically more valuable than the negative infraction. So having that positive incentive matters. The difficulty is the scale. Right? When you're talking about hundreds of millions of dollars of outstanding court debt that are being assessed on Oklahomans on an annual basis, just massive amounts of court debt being assessed to Oklahomans across the state on the municipal level, the district level, and in the civil legal system. In order to really right size that on the scale that's necessary, we need to eliminate some of these fees. I think on a bipartisan basis, our lawmakers agree there are a whole bunch of these fees that have absolutely nothing to do with courts. They don't have anything to do with public safety. They don't have anything to do with the guilt or innocence of defendants. They are literally just revenue generating mechanism. taxes, right? And so the best thing that we can do is to eliminate those taxes, just write them out of the code and to fund those agencies. One of the pieces of this that I find the most pernicious is the fact that there are victim services on this list. There is one of the bills that Ryan mentioned, Senate Bill 1458, that Senator Thompson did, that $40 million reduction. One of those lines of fees that Senator Thompson hoped to erase with that legislation pays for a trauma hospital in Norman, Oklahoma, that serves people who are survivors of domestic violence, that serves children who've gone through significant trauma. And our argument is not that we shouldn't be funding those resources. Our argument is that we should never be waiting on the fluctuations of court fees, depending on the random dockets that may or may not happen, to say that child trauma should be a fluctuating revenue expense. It should not be. We should be invested in child trauma. We should be invested in the victims of crime. We should be invested in protecting domestic violence survivors. And that means that should be annual appropriations that aren't subject to the whims of court dockets and fines and fee collection. So I think there is really the most important piece of this is getting this financial burden of these exorbitant fees that aren't helping law enforcement and courts, getting that burden off and actually appropriating for public safety.
Thanks, Damian. And so I have two final questions. So we're going to make this a lightning round, but I want both you, Ryan, and you, Damian, to answer these questions. So first one, and then I'll ask the second one here in a second, is what's next for your organizations in the coalition? What are you going to be focusing on in Oklahoma? What particular policy solution are you going to be advancing in 2023?
I will just say at this point, I can't say that I've got an agenda on fees specifically, but certainly going to look at tackling some of the things that lead to very large court debt.
Yeah, and I think probably Oklahomans for Criminal Justice Reform will be most focused on Senator Thompson's reform. He is still committed to doing something in the $30 to $40 million reduction of existing executive agency fees. I think that would be transformative for a number of Oklahomans across the state and transformative to the system. So that really will be where most of our attention is focused. We'll also be looking at mandatory minimum fines and fees, specifically in a felony classification bill that we're working on right now, really taking a lot of those minimum fines specific to offenses like drug trafficking and other things that just aren't calibrated for judges to have the discretion they need to say, we don't feel that this, in some cases you can be looking at many tens of thousands, more than $100,000 of fines and fees or fines for some of these offenses, depending on the nature of how they're written in statute. So those are the two big that we're looking at right now.
Yeah, and we will certainly be supportive of the Senator Thompson bill as well. Again.
That's excellent. And kind of the second lightning round question, since we're coming to the end of our time, that I wanted to pose to you guys is that you've had some great successes and a few losses in Oklahoma. So what are one or two lessons that both of you would want to share with the other advocates watching today to hopefully prevent them from having to go through to either catalyze the success that you've had or to prevent some of those losses that you guys have seen in Oklahoma?
Yeah, sure. And I'll go first. I mean, I think the number one thing is that data and information is power. It's really easy. I used to think that this was unique to Oklahoma, but now as I talk to people across the country, it's just not. I mean, we oftentimes don't know what we don't know when we start out looking at some of these problems. Are these fees being paid to these agencies sort of pro rata, or is there a hierarchy and a pecking order, or who, like, when the court collects it, where does that go? And those things, it's really easy to, in the middle of a legislative session, the lawmakers want to know the answers to those questions. And if we don't know, it just like gums up the process. And so, it doesn't really have anything to do with this call, but Damian and I worked on a clean slate bill in Oklahoma this year, and I think just the legwork we were able to put in on the front end, really understanding, and I had a leg up in that process because when I was in private practice, I did expungements, and so really knowing the landscape procedurally for a lot of this stuff is really helpful. And the other thing I would say is I just think you have to find people who are going to be good advocates for your bill. And this is, I think that sounds like, well, duh. But for me, it's not always that simple. Like I get caught up in sort of like wanting to play the politics of the building, right? And, wanting to have so-and-so run the bill, when in reality, sometimes someone that, I may not think is as effective as somebody else, but they're really passionate about this issue. Like getting those people on board and then just unleashing them to do what they do and use their passion for court debt and helping people who are trapped in this sort of never-ending spiral of fees. I think that can't be overstated.
I think, definitely want to co-sign a number of those comments from Ryan. I think in the clean slate space and in the fines and fees reform space, we've been able to build a coalition that probably seems fundamentally insane in other spaces, right? We have the most conservative right free market think tank in the state of Oklahoma, and we have groups like the ACLU of Oklahoma, sitting at the same table together, working on legislation together, trying to build consensus. I think in 2022, so many Americans nationally are bored with the binary politics of conservative versus liberal, and they are looking for solutions. They are looking for people who make their kids' lives demonstrably better, who make their families' lives demonstrably better, who make their zip codes demonstrably better. And that requires action more than ideology and a deep desire to find consensus. Something I'm always listening for are what are the things that people from every perspective in our stakeholder groups, in our universe, what are they all saying? There are so many more things that unite rural Americans and Americans, Black and brown Americans in communities of color. They are experiencing so many of the same problems and issues right now that I think the politics that it has existed for the last 20 to 30 years hasn't caught up with the reality of the new coalitions that can be built around these issues. So more than anything else, I think that's what excites and animates me.
Ryan, Damian, thank you so much for just sharing your wisdom, sharing your experience from Oklahoma. I know it's been my honor at AFP to watch what you guys have been doing and to be involved in what you guys are doing there in the great state of Oklahoma. So really looking forward to continuing efforts in 2023, continuing to work with you both and learn from you both. And I hope that the people that are joining us today learned as much as I did during this conversation and as much as I have learned from you guys. So looking forward to continuing to elevate your successes and your lessons to others across the country. And thanks again to our leadership here at AFP, leadership at ACLU, and Fines and Fees Justice Center for wanting to launch this platform so that all of the folks listening today can learn from those lessons across the states. Because I think a lot of times we candidly operate in silos in our state coalitions. And so I think it's good to start breaking down some of those silos and be able to learn from each other. So thank you to everyone that joined us today. And thank you for this great conversation, Ryan and Damian. I hope you guys have a great day.
What a fantastic conversation. It really highlighted how people are working together, laying the groundwork, and pushing their policymakers in the direction of progress. This work isn't fast or easy, but it is possible at a time when many things feel insurmountable. The work of economic justice, the work of ending fees in the justice system once and for all, can be achieved. Oklahoma is just one of the many examples of how fee reform is taking place across the country. In just the last week, the governor of California signed a bill to end phone call fees in prisons and juvenile halls across the state. And the governor of Delaware signed a bill ending public defender fees, probation fees, late payment fees, and juvenile justice fines and fees, along with others. And that's just the beginning. Today, we launched our new website, endjusticefees.org. This site will be a resource to the coalition and the public with everything we know and continue to learn about justice fees. On this site, you can monitor the national momentum and keep track of state and local reforms. You can also access our 50 state surveys on the specific fees around the country. And of course, you can join our national coalition from this site, so you can stay engaged on this issue, request technical assistance and support, and continue to build this network and add to the existing momentum of fee elimination across the country. Today is just one day. It is the first day of our national campaign, but in no way the first day of this work. It is the beginning of an effort to provide national support to legislative agendas, promote education and awareness around this issue, and leverage and learn from the amazing work being done by so many of you across the country. FFJC wants to thank the many people who played a role in making today happen. Internally at our organization, the great work of our research team, Tim Curry and Tanisha Perret, our communications team, Jack Davies and Felicia Montalvo, and to all the staff at FFJC who are doing this work day in and day out, and to our leadership, Lisa Foster and Joanna Weiss, who have not only had a vision for this organization and our mission, but do so much of the work in advancing these reforms. And outside of our organization, thank you to the steering committee partners at AFP, Jeremiah Mosteller and Greg Gold, and at the ACLU, Emily Dindile, and so many of our other partners who are playing key roles in the advocacy and advancement of fee elimination across the country. Before we officially end today, and we want our partners at the ACLU to share some final thoughts with you all about the importance of doing the work of ending fees in our criminal justice system. We hope today has achieved our goals to inspire you, reinvigorate your commitment to this work, and raise more awareness about the issue of fees in our criminal justice system. We thank you all for your time and your commitment to the work, and we look forward to working with you all to end justice fees.
In theory, fees are not intended to be punishment, but in practice they are. Fees are added on to existing punishments, such as fines and incarceration, which are already harshly punitive. The criminal legal system does not need to double down on punishment. Fees in the criminal legal system function as perpetual punishment for people already most targeted by predatory systems of mass surveillance, policing, and incarceration, Black and brown-bodied people. People who shoulder the burden of funding of courts as governments are constantly creating new categories of fees and increasing existing fees in order to offset the bloated budgets that support mass incarceration. Take, for instance, one of the participants in our 2021 report, Reckless Lawmaking, who had a ticket for illegally tinted windows, a non-moving traffic offense, which carries a hefty fine of $150. After more than 10 categories of fees were added, he owed over $1,000. That extra $850 was not used for rent or for food or to support his family. People like this participant should not live in fear of being perpetually criminalized. Predatory fees can be the source of this fear. And for Black and brown people, who are significantly more likely to be targeted by police, that fear is a reality. Predatory fees encourage policing for profit, criminalize poverty, and endanger Black and brown lives. We deserve to live without fear of perpetual criminalization, and we deserve a fair, transparent government. Thank you for your good work on these important issues.